Next one is Doss, Green, and Tang versus LANDQUEST.
Good morning, Your Honors. Steve Hallgren on behalf of the appellants.
You wish to reserve any time, sir?
Yes, sir. I appreciate it. I can reserve 5 minutes.
You've got it. You may begin, sir.
Good morning, Your Honors. The issue we have today is whether the trial court acted appropriately and with jurisdiction when it amended a second amended final judgment after that second amended final judgment had been appealed to this court, had been affirmed, and a mandate was issued. Based on the briefs, I know one of the issues the court may be curious about is the standard of review. I'd like to take a moment to address that. While preparing for my oral arguments, I found a case which is instructional on the standard of review. It's State Farm Mutual Automobile Insurance Company versus the judges of the 5th District Court of Appeal.
I'm sorry, did you cite that in your briefs?
No, Your Honor, and
A supplemental authority?
No, Your Honor, I didn't.
You can't really argue at this point. You may supplement after the arguments, but you can't bring it. That's unfair.
It's not fair to opposing counsel to bring up a case that you didn't cite in your brief or note. He can't respond to it because he hasn't seen the case.
Well, our whole argument doesn't rest on that, Your Honor, and I'll put that as
Counsel, let me ask you, we've read your briefs on both sides and we're familiar with the record. There's a portion of the record in which Judge Hauser said this is clearly a clerical error. What weight should we give to that?
Your Honor, I believe there's no weight to be given to that until you determine that the jurisdiction is appropriate. I believe it's a de novo review until you determine jurisdiction, and if you determine jurisdiction.
But isn't that statement, I mean, let's assume that that's similar to a finding of fact. If that's the case, then doesn't that really determine how we approach the issue of jurisdiction?
I do not believe so, Your Honor. When you look at jurisdiction and you look at interpretations of a rule and you look at interpretations of a final judgment.
You can see we've got two rules that we're dealing here with. It's either one or the other, right?
Rule 1.540A.
A or B?
Yes, sir.
Okay.
And if we look at Rule 1.540B, we know that rule is of no use because it was more than 1 year before the
but if it's a clerical error, then A applies.
It would be the applicable rule, Your Honor, if there wasn't an appeal and affirmance. We've cited cases, and the most close case on point is Local Consumer Enterprises Court versus Hadley, and that was reported at 404 Southern 2nd, 1155. It's Florida 2nd DCA decision of 1981. And that case really instructs us because in that case there was an appeal and there was an affirmance, and the court specifically allowed the correction of an error under 1.540 on remand. And quoting from the case, it says, while it's normally true that an affirmance on appeal when final renders avoidable judgment.
But how does the appeal, if it's a clerical error, it's a clerical. If it's not a clerical error, it's not. I don't understand the relevance of the other case in the appeal and the affirmance of it.
The relevance, Your Honor, is that the mandate is the key.
Mandate from this court.
The mandate from this court, Your Honor. That means that the judgment of the second amended final judgment became the judgment of this court. And there's only 2 exceptions in that case that the trial court has authority to amend that judgment. And when I say amend, they can address ancillary matters like attorney's fees and costs, and they can enforce the judgment, which we know from case law means issue writs of execution and proceeding supplementary. Those are the only exceptions under the case law.
So why would we have a rule that says that if you make a clerical goof up, you can correct it, but there's no time limit on it? And yet we're engrafting an exception on that by saying it can't be done if it's after amendment.
Well, Judge Monaco, the rule, it's inherent in the rule that it talks about special procedures when an appeal is pending. It talks about needing to seek permission from this court to relinquish jurisdiction. The rule doesn't go on to say, oh, no, by the way, and when you lack jurisdiction, don't even bother moving to correct a clerical error, because the case law deals with mandate. And I've got 5 or 6 cases that says the law of court is clear that after an appeal of a judgment and its affirmance, by an appellate court, the trial court is without authority to take any further action in the cause other than to carry out the mandate of the appellate court. That law wasn't changed by Rule 1.540A. And to have the rules incorporate all case law is unnecessary. The plain reading of the rule is there's a heightened standard when an appeal is made. You have to ask the appellate court to relinquish jurisdiction. Appellee would have you believe that that standard somehow goes lower again once you've issued your mandate, once things have reached the conclusion, once they become final.
So your position is that once the mandate's been entered, that clerical error can never be corrected after the appeal?
Your Honor, it's our position, the appellant's position, that that clerical error can only be corrected if it's asked of the appellate court to recall the mandate within the term that that mandate is issued. If you wait beyond the term that that mandate was issued, neither the appellate court nor the trial court can correct that amended final judgment.
You would concede that's not in the rule itself. It's just your interpretation of how the rule ought to operate?
Yes, Your Honor. I mean, this is a case of first impression, as Judge Hauser said. The case I cited, local consumer enterprises, is as close as we can get, and that suggests that jurisdictional rules were not thrown out the window when they wrote Rule 1.540A. That's a rule and deals specifically, but the fact is that when you don't have jurisdiction, you don't have jurisdiction. It may be circular reasoning, but all of the case law and jurisdiction was not thrown out when they put in Rule 1.540.
But doesn't the rule impliedly give the circuit court jurisdiction to correct a clerical error? It seems to me that my reading of the rule seems to indicate that maybe they lost jurisdiction when it was appealed, but the rule then vests them with jurisdiction to correct any clerical errors.
When you say them, do you mean
the trial court?
The trial court has that authority if permission is requested. There's case law by this court saying that if permission is not requested, and I've got the cases, if permission is not requested from this court, then that judgment is void. I mean, that's significant, saying you don't just tinker with the judgment when it's up on appeal.
Including, do any of those cases deal with clerical errors, or are they substantive?
They're dealing with any changes. They're not just clerical errors.
But the cases, though, really aren't, I mean, they're all distinguishable from this particular case. This case is just a simple case of a clerical error. It's not a situation where they're changing the amount of damages, or they're changing the who won the case, or something along those lines. They're just changing the name of one of the parties, or two of the parties, I guess.
With all due respect, Judge Poyce, I think there are three changes between the second amended final judgment, and if you look, it's the amended final judgment. The second one is why we call it the second, and then the third amended final judgment. First, the names are changed from LANDQUEST to Goodwin, and from Goodwin back to LANDQUEST. Second,
Goodwin is the 100% shareholder of LANDQUEST?
Yes, Your Honor.
How is your client hurt by that?
Yeah, what's the practical effect of it?
The practical effect of my clients under the second amended final judgment are faced with paying $300,000 plus interest, their worst day, and after the amendment, they're possibly going to have to pay as much as $2 million plus interest. It's significant.
Simply because of the
name
corporation changed to an individual, or individual changed to a corporation?
Well, it was more than just that, Your Honor, and the second change was that who was to pay the judgment. If you look at the second amended final judgment, it really doesn't say, it says for what somewhat execution issue. It doesn't say who's to pay the judgment, and if you look at the judgment itself, the caption, it says my clients, the appellants, individually and as successor trustees. So they were dismissed individually, so it's really confusing, the second amended final judgment. In the third, they specifically say that my clients...
Why didn't you bring, if you knew that it was, that they had the wrong defendants, why didn't you bring it up at that time?
Your Honor, I was not involved in the case until Doug Spears got a conflict. Someone moved an office or something like that, and so I was retained. I have no idea what strategy calls were made back at that time. All I know is that this is analogous to a situation and in a criminal context where someone's challenging an illegal sentence after they've allowed that illegal sentence and then went ahead and accepted that illegal sentence subject to community service. They violated community service, and then they complained of the illegal sentence. In Sorzik versus State, this court, in an opinion issued by Judge Monaco, said you can't do that. There's a stopple.
That's a criminal case,
Yeah, they're different rules.
Yeah, they are.
Talking about taking away somebody's life, it's different than dollars.
Well, the analogy is, Judge, they changed the names, they changed who was to pay the judgment, and they changed under what circumstances the judgment would be paid. Those are substantive errors. We've got cases.
Circumstances under which it would be paid. Explain where that change is.
Do you have a timeline by any chance, Counsel?
A timeline?
Yeah.
Yes, Your Honor. What would you like to know specifically?
Tell me, I have the original final judgment here. Why don't you run through this? When was the original final judgment?
The original final judgment, the initial judgment I have is January 2, 2003, and that was where Mr. Siegel and LANDQUEST split 5%. That's in the record at R.
When was the mandate issued?
The mandate was issued, Your Honor, February 15, 2005.
Okay, and the other three judgments, when did they come?
The amended judgment, the initial amended judgment was January 15, I'm sorry, the initial judgment was January 2, 2003, the amended judgment, January 15, 2003.
Okay.
The second amended final judgment, again, it's captioned just as an amended final judgment, was rendered August 18, 2003, according, it's either August 14 or August 18. I believe it is August 2003. And the third amended final judgment, Your Honor, was entered, I believe, on August 11, 2005. I'm not sure when it was rendered, but it would have been shortly thereafter. So what we have is, we have significant changes, which are substantive changes in the nature of, not in the nature of clerical errors in this case. The court not only exceeded its jurisdiction, but attempted to sort of get it right and to do what I think the court intended to do in the first place, but those are the types of errors that are covered by Rule 1.540B.
I want to ask you, didn't the original complaint, maybe I'll pick this up wrong, but didn't the original complaint refer to the individuals as land trusts? I mean, weren't there individual names in there?
Your Honor, I believe the original complaint referred to my clients individually and as successor trustees. I don't have that in front of me, but I know that it came up in the issue when they were trying to amend the second amended judgment. They were trying to still hold my clients individually liable, and I point out to Judge Hauser, I said they're also trying to do that, and they've dismissed my clients in their individual capacity. So there's just been multiple changes throughout this. The errors are significant. The errors have a big impact on my client. The errors are substantive.
Counsel, let me make sure I understand your position. You're telling us that there is nothing in the record that explains why this clerical error occurred.
I believe
Not what you believe, but what is there anything in the record? My reading of the transcript of the hearing before Judge Hauser didn't illuminate me at all on how these clerical errors occurred. It was just brought to the court's attention, and the judge said, well, clearly they're clerical errors, and went on and ruled that they should be corrected.
You're absolutely correct, Your Honor. I was just going to say the appellee surmises why it may have occurred because it took a long time. I don't know. The judge didn't specifically say these are the reasons why this is a clerical error. The comments to Rule 1.540A suggest a clerical error is a slip or omission. We know if you look at the number of words.
I was going to ask, do you think this was a clerical error?
No, Your Honor, I don't. I do not. I think it was a substantive error. It changed the parties. It changed who was liable under the judgment. And those are two significant things. And it's not just the names of the parties. If you compare the language, there's a lot of different changes. I bolded them, changing Goodwin to LANDQUEST 2 times, saying it's to be paid by my clients instead of just before it said for which let execution issue. And then it said if there's any further payments, it used to be payments by Mr. Miller, that Mr. Goodwin would be entitled to 5%. Now it says if there are any payments made by the purchaser, then my clients, the defendants, shall pay the the amount. So those are 3 changes by my count. It's not a slip or omission. It's a,
We'll grant you their changes. I mean, that's obvious. But I still don't understand how they really have impacted your client.
well, Your Honor, Mr. Miller personally didn't make any payments after the initial judgment was entered, but the purchasers did, and that's a difference of $1.7 million plus. And so if we go back to the second amended judgment, I think Mr. Goodwin's going to get $300,000 plus interest, and if we don't, I think if you affirm instead of voiding the third amended final judgment, I think we're looking at over $2 million.
But wasn't that part of the original judgment anyway, that the money kept coming?
It was part of the original judgment that if there were further payments by Mr. Miller, then Mr. Goodwin would get a certain percentage of those, Your Honor.
Got 5 minutes.
Thank you, Your Honor.
May it please the court, good morning. I'm Joe Williams, and I represent the appellee LANDQUEST, Inc. in this proceeding. I think when you peel all of the layers away from this particular onion, and I'm talking about misrepresentation to the court concerning the appropriate standard of review, I'm talking about the misrepresentation to the court in briefs that a 1-year limitation applies to Rule 1.540.
These are not misrepresentations. They may be incorrect interpretations.
pretty strong
But misrepresentation implies that there's some kind of a fraudulent motive, and I think that's you're stepping on some pretty thin ground there, counsel.
Fair enough, Judge. But the fact remains that the representation was made to the court that 1.540A motions have a 1-year limitation based on that. Most recently, as I filed a notice of supplemental authority in the reply brief, the appellant cited to a case that was unpublished in the Southern Reporters by the Supreme Court for authority of appointment making. That opinion was withdrawn by the Supreme Court of Florida. And
Kephart?
Yes, Your Honor. And
Counsel, why don't you let's talk for a minute about clerical errors versus some other kind of error for.
Can I give you a little background? There was some question about whether or not there was anything in the record that indicated this was a clerical error.
Lightness on that, sir.
I think there is an explanation there. The first judgment was entered January the 2nd, I think was correctly. There were some scrivener's errors in that judgment, and all of the parties agreed to have the amended judgment entered on January the 15th to just correct the scrivener's errors. Then there was motions for rehearing were filed by LANDQUEST and by Siegel. The hearings on those motions, there were 2. The last one was, I believe, in May of that year. And then in August of that year, the court, without any other consultation from the parties, the court entered the judgment that we're talking about today using the names Mr. Miller and Mr. Goodwin. The other thing that is important for the court to understand here is that Mr. Miller is involved in this case because as the purchaser, he was required to sign an indemnity agreement with the land trust. And that agreement required him not only to indemnify the land trust if there were a claim for a real estate commission, but it also required that Mr. Miller provide the legal representation on the claim. It became so convoluted that Mr. Spears started out as the attorney for Mr. Miller in a cross-claim action between him and Mr. Siegel. Between him and the land trust. And then when those issues were involved, Mr. Spears slid into the chair as the defense counsel for the land trust. So all of this was going on over the course of the litigation, and names were interchanged all the time during that litigation, and it is understandable to me that Judge Hauser, 4 or 5 months after the last hearing on, after the last rehearing on the case, trying to get an order out, could have used the names that were used most frequently in the proceedings before him, Mr. Miller and Mr.
How long after you received that judgment did you schedule a hearing to have the correction made?
We received the mandate from this court approving per curiam the judgment, and I scheduled, and this is in the record in the motion I filed in the record. I scheduled a meeting with counsel for the Land Trust, who's not Mr. Polgren, who's representing them here today, to discuss collection of the judgment. I was told at that time, well, we're sorry, but this judgment can't be executed because you got the names wrong. Or Judge Hauser got the names wrong.
Who were they referring to? Which names did they contend were wrong?
Miller for the Land Trust and Goodwin for the LANDQUEST. And once Siegel was out of it, those were the only two parties that were left. And it's important when you look at the first judgment, the proper names were used for LANDQUEST and the Land Trust. And then in the judgment that we're talking about that was entered after the rehearing process, that's when the personal names crept into the judgment rather than the names of the institutional plaintiff and defendant in the case. So the way this thing was tried, the intermixing of interest in the thing, the use of individual names throughout the process rather than the LANDQUEST and the Land Trust, I think that explains why Judge Hauser made the mistake that he acknowledged that he made on the record in the hearing on the motion that we filed. And I think I've given the court the authorities that say that these kind of mistakes, misnomer of the parties, are clerical mistakes.
I guess I'm most interested in knowing whether or not, even if it was a clerical mistake, whether it can be modified after the mandate from this court approving the prior judgment. I mean, that's an interesting theoretical question for me.
Well, all I can tell you is I can't find any direct authority on that issue, and I don't think there is any.
It makes it sound better reading either. So.
But I did cite to you St. Cloud Utilities versus Moore, this court's decision, and this is what this court said about the viability of Rule 1.540A. The Supreme Court has already dispelled the notion that the time within which an appeal may be taken from a final judgment has anything to do with the continued jurisdiction of the trial court. And that's Shelby Mutual Insurance Company case of the Supreme Court. Continuing the quote, the trial court loses jurisdiction except to enforce the judgment and except as provided by Florida Rule of Civil Procedure 1.40 when the time for filing a motion for rehearing or new trial has expired, or if such motion has been timely filed in Rule 5. That doesn't directly address the issue either, but that's the closest I can find. And if you accept the argument here, you're going to have a bifurcation of when Rule 1.54A applies. If there is no appeal, it goes out for eternity. You can come back any time and get your clerical error correct.
Well, why isn't that a good idea if it's just a clerical error?
I'm sorry?
Why isn't that a good idea if it's just a clerical error?
I'm not saying it's not a good idea, but what I'm saying is it's a good idea if it's a clerical error, regardless of whether or not the case was appealed.
Well, I mean, that's the difficult part. That makes perfectly good sense to me.
Okay.
But it's difficult to reconcile that with having a prior judgment approved by the appellate court, which would, with the issuance of the mandate, put it to bed. And while it makes a lot of sense to me to allow the trial court to correct it's clerical errors at any time. I'm troubled by the notion that, you know, there's a tension between the issuance of the mandate and the correction of the error.
Right.
Do you not see, I guess my question is, isn't there a substantive effect to this clerical change? Isn't there a material effect on the other parties?
I don't see any substantive effect. What it did was make the properly name the judgment debtor and the judgment creditor. And you have to understand that at the time of the first judgment, the only thing out there was, as Mr. Falgren indicated, was a $300,000 down payment. I'm sorry, a $6 million down payment, which would have resulted in a $300,000
Commission.
But now the property's been paid off, and so
5% is worth a lot more at this point.
Obviously, but we could not have executed on the entire judgment at the time Judge Hauser entered the third amended final judgment, because the money was not there to execute on.
I guess my question is, shouldn't it be brought up before we get to the appellate court when we see these things? Shouldn't that have been brought up at some point before or during the appeal?
In a perfect world, that's true. That should have been brought up. And it was, when I looked at the, and I handled this in the trial court, and when I looked at the first judgment, the names were proper, and it was done properly. And I made the mistake of just assuming that when Judge Hauser did correct the clerical errors, or when the judge entered the order following the rehearing and denying Mr. Siegel's claim and allowing Mr. Goodwin's claim, that he would have used the same locution in the January order as he did in the August order. And this did not really come to my attention until I sat down with opposing counsel after the appeal and said, we want to talk about collection, and that was when I was told, well, we think you have a problem with execution. Now, obviously, they knew about it before then, and they could have, if this had been as important to them then as they claim it is now, they could have brought it up themselves. The rule says any party can bring this up, but they didn't. Obviously, that was a strategical decision. But well,
there's nothing in the record about that, is there?
I'm sorry?
There's nothing in the record about whether it was strategic or not.
Oh, no, that's a trial lawyer's assumption that it was. I'm not trying to say that was in the record. But the fact remains that if you look at the first judgment, the parties were entered correctly, and you look at the judgment after rehearing, the parties were not correct. Judge Hauser's original intent is shown by the first judgment. He named the parties correctly in the first judgment. And when he said on the record at the hearing, I obviously made a mistake, that conclusion is bolstered by the fact that he used the proper names in the first judgment. Let's see.
You got a minute left.
Thank you. I would just, the other point I would make is I think the St. Cloud versus Moore case is an important case for the court to take into consideration in this. And I would point out that the appellant did not respond to that case in its reply brief. Thank you for your attention.
Yeah.
You have 5 minutes, sir.
Yes, sir. The mandate is the key. The appellee sought the mandate below for the second amended final judgment. They got what they asked for. They should be bound by it. There's no good faith exception to the jurisdictional rules. The appellee hasn't distinguished my local Consumer Enterprises Court versus Hadley case, which is the closest case dealing with whether 1.540 is applicable after an appeal and after the appellate court has ruled. And In that case, the appellate court said, this is okay in this case because we specifically remanded with instructions to the court to consider the merits of the Rule 1.540 motion. That wasn't done in this case. This is the closest instructions we have to what we should do in this case. None of the cases he cited, and he asked me to distinguish them, involved an appeal and affirmance. Local consumers is much more close on point. The substantive effect of the changes is significant. One says Mr. Miller, when he pays for the property. The other one says when the purchaser. The one that says the second amended final judgment says when Mr. Miller pays. It's never, that condition never occurs following the entry of that judgment. And so it's a big distinction as to what my clients would have to pay. We cited the Frizard versus Frizard case, and that really supports the fact that this is a substantive error. It is a type of error that would be dealt with in 1.540B. And Frizard, the trial court tried to add a provision for attorney's fees, saying it was essentially an error, and it's not a substantive error, it's a clerical mistake, and it was reversed by the 4th District Court of Appeals, cited at 497 Southern 2nd, 885. You can't simply rewrite a judgment and call it what you want. It's a substantive error, and we've respectfully asked this court to vacate the third amended final judgment and the order granting leave to amend. Thank you.
Thank you.